Well, hello friends, and welcome to another WSIB Truth Matters with Joe Machado, where I separate the truth from bullshit, facts from fiction, in plain English. Today we're going to talk about a subject that I think is of interest to pretty much everybody who has a claim with the WSIB. And I'm going to offer some tips, so let's get at it. And we're back. So I hope you're finally your feet are firmly planted in 2025, and that it is a much better start to the year as last year. I know that a lot of people have problems that are carrying over from last year, in particular dealing with their WSIB claim. And it seems that it's inevitable, regardless of whether you claim it happened 2, 3 months, 4 months ago, or 20 years, and you're still fighting for benefits. So today I'm going to talk about something that I think could be helpful, because I get asked this question quite often, and that is how to avoid problems with your WSIB claim. How to avoid being cut off or having your benefits reduced. And I'm only going to talk about active claims. Any claims that have been denied, then of course there's the appeal system, there's the reconsideration request and all that. And you can email me for those and I can be more specific. My email is in the description, in the video description, and also I'll post it up here as well. But yes, it is a concern that most injured workers have, or ill workers or dependents, as far as their claim is concerned. Because let's put it this way. I think everybody knows that when you have a WSIB claim, you're going to run into problems at one point or another. If you're lucky, and on multiple occasions if you're not as lucky. And this is based on over 30 years of experience, as you know. I don't pull shit out of the sky. I talk about my own experiences and my paralegals' experiences and those that we've had over the last 30 years with thousands of cases handled. The most important factor in avoiding problems with your WSIB claim is knowing your rights. Understanding the law and the policies that are applicable to your claim. And so in the last 40 years, there have been 3 major changes to legislation that affect the structure of benefits. Some of those changes came before January 1st, 1989. That applies to what we call pre-1990 claims. Some of those changes applied when Bill 162 came into effect, January 1st, 1990, for claims in that period up until December 31st, 1997. And then the third major change to the law was on January 1st, 1998 for claims beginning on that date to present under Bill 99, covered under the Workplace Safety and Insurance Act. So I don't expect you to know all of those laws, and I certainly don't expect you to know all of the laws that are applicable in your particular claim. However, knowing your rights is important. Lucky for you, there are people like me who have extensive knowledge and experience in dealing with all of those laws. And when I'm talking about experience, I mean that they've actually handled more than 1 or 2 cases, perhaps a few hundred or a few thousand. Then there are policies, and these policies are created by the WSIB. So the law, the acts are created by legislators, lawmakers, and they create the laws which form the Workplace Safety and Insurance Act or the Workers' Compensation Act before that, and so on. The WSIB in turn will create policies on how they will adjudicate those laws. And those policies may or may not be formulated and applied within the intent of the law. And this is where the Workplace Safety and Insurance Appeals Tribunal, which is this external agency that has the power to overrule WSIB, this is where oftentimes they will say to the WSIB that a particular policy that they've applied in a case that they're reviewing and adjudicating and making a decision regarding an appeal isn't consistent. And that can lead the WSIB to change or modify some of those policies. Those policies can number in the hundreds. So they have policies in terms of return to work, about cooperation, about how claims are handled, how they're adjudicated, entitlement decisions, survivor benefits, dependents, so many, on and on and on. And so understanding the law and the policies that apply in your particular case is important. So the other thing that is really important is to work closely with your healthcare professionals. Now, I know, and you've heard me talk about this a lot on this channel, if you've been a viewer or subscriber. And you've heard me talk about how the WSIB often overrules your doctor's opinions. But that should not be a reason to not work with your medical professionals closely. Because at the end of the day, whether the WSIB wants to or doesn't want to accept the opinions provided by your doctors, and there is an appeal, and if you've worked closely with your doctors, the tribunal will definitely consider that information. And it could work in your advantage. So even if it seems like they're not listening to anything your doctors are saying or any treatments that are being prescribed, don't let that be a deterrent or discourage you from making sure that you continue to work closely with your doctors to help you recover as much as you can with your condition. And if you end up in an appeal situation, then you're going to have that medical to support you at the tribunal. And you know what I feel about the Workplace Safety and Insurance Board's Appeal Services Division. I think they're useless. They don't like to hear me say that. I don't really give a fuck, but I tell it like it is on this channel. And I think they're useless, and that's based on my having dealt with them over many years. Anyway, so the other part, another top or another advice or hint or tip is to be proactive with your case. And what do I mean by that? Well, keep detailed notes and records of everything that happens in your case, whether it's been a conversation with the Workplace Safety and Insurance Board, which I highly discourage. I strongly recommend that everything is done in writing and that you insist upon it for various reasons, and I've touched upon that on various videos on this channel. But I can tell you some of the key reasons. One of them is I don't trust them at all, and they know this. And oftentimes I will review a client's case, and there's stuff in there about a conversation that apparently took place between a WSIB official and the client, and it didn't reflect the accuracy of that conversation. So that should give you an indication. The other one is it gives you an opportunity to think about it, to learn about the law that may apply in that particular situation so that you're prepared, or to discuss it with someone who can give you proper guidance and advice as to how to deal with that situation. So by being proactive with your case, keeping detailed notes of conversations with the WSIB, the date, who you spoke with, what was discussed, what was expected out of that conversation, or a visit with your doctor, a meeting, what was discussed. If there's a medical report, to get a copy of that medical report, put it in a file. We have an incredibly amazing tool with my company, WSIB Settlements, that I developed personally on our app, which allows you to do all of this in the most user-friendly and the simplest of ways, where you don't have to write everything down and you don't have to think or remember about all of these things. They can be documented if you need them later. But anyway, getting back to being proactive, make sure that you keep all of these notes and records in the event that you need to rely on them down the road. And what I mean by down the road is another conversation with that same person or some other person involved in your claim or some other specialist involved in your claim. And you have that information to rely on so that you can go into it knowing exactly what the situation was, how you documented it, and then to prepare you for that situation. But it'll also be very helpful in a hearing or an appeal situation with the Workplace Safety and Insurance Board's Appeal Services Division, or more importantly, with the Workplace Safety and Insurance Appeals Tribunal, if you find yourself in that situation. All of that information can be extremely helpful. I don't mean to create work for you, but this is the world we live in, my friends. And if you leave it to others and you don't take care of these important tasks, at the end of the day, I think you're going to find that it's going to hurt you. So please do that. Make sure that you protect yourself by documenting everything when it happens, not days later or weeks or months later, because memories fade. It's hard to recover those memories, particularly if you're receiving treatment and if you're taking medication that may affect your memory, whether it's short-term or long-term. So just do yourself a favor, just write it all down, document it, put it in an organized folder or use the portion of our app. And then I'm not going to say that you're going to be 100% okay, but you'll be ready for battle in the event that it needs to happen. The other thing about being proactive is object to anything that you don't agree with immediately. Don't wait a week or a month or days or years. If something doesn't sit right, a decision that's being made, or you feel that you're being pushed into something that you're not really able to do, whether it's in the return to work situation or whether it's in medical rehabilitation, make your objection noted immediately. And this has to do with also some of the legalities around time limits on appealing. So any return to work matters. There are 30 days that you can appeal that decision. And any other decision made on your claim, there's 6 months. And so it doesn't mean that in 30 days you need to know exactly how you're going to argue the case or present it or what issues or what information you need. You don't have to provide any of that. Just state it in writing, send them a letter, update it, upload it to your through your account, get it on file. And even if it just says, I object to your decision of such and such a date, and put your name on it and upload it or email it or fax it or whatever and get it noted on file. And then you can deal with it later. Whether you want to pursue that appeal or not, that's something that you can decide later on after you've considered the matter fully or after you've had a meeting with someone who helps in this area, such as our firm. And then at that point, you can determine whether or not it makes sense to go ahead with an appeal, or there may be some other method of resolution that doesn't necessarily require an appeal. But the key thing is object immediately so you protect yourself and you can then pursue it at any point down the road. Okay, so the other one is cooperate in return to work activities. Now, cooperating in return to work activities doesn't necessarily mean that you have to go into your job and you have to go and do your pre-injury job or some other job that they give you and follow everything that your employer and the WSIB wants you to do. That doesn't necessarily mean that. It means that you can explore options with the WSIB and your employer and have discussions about potential options. And so that is cooperating. Now, whether or not you follow through with what they expect you to do, whether it be the WSIB or employer or both, then you can work with your doctor or doctors at that point to get their opinion, to get their input as to whether or not those activities that are being recommended or suggested by your employer or the WSIB, whether or not they're safe and they're suitable for your restrictions. Okay? So that's important. But it's very, very important that you work with your doctor and that you follow your doctor's recommendations. And if your doctor says, listen, why don't you give it a try? You might be able to do that. Then I'm not telling anybody to do anything that they don't want to, but I would suggest that you give it a try. And if it happens that you're not able to do that, then you go back to your doctor, who will then properly document it and explain to your doctor what you were doing, where it became a problem, so that your doctor can then properly document it and make sure that the WSIB has it in their hands. Which leads me to the next tip, which is that it's important that you make sure, don't assume anything. My policy is don't assume, always double check, triple check. So if you have had a medical treatment of some sort, or if you have an assessment with a medical professional, or if you had some kind of a test done, make sure that the WSIB has it in their file, because the WSIB will periodically look for medical information to make decisions. Again, it doesn't necessarily mean that they will always agree with your doctors, but you know what? As long as it's on your file, get it in there. Don't think that, oh, I'm going to let my doctor submit it or whomever. Make sure they did. All right? And better yet, make sure you get a copy for your own file. But get it logged in your file. The reason being is that in the event that you need to have an appeal and you're before the tribunal at a hearing, then you can say, well, listen, yes, this is what my doctor recommended, and it was on file, and I'm following my doctor's recommendation. And the WSIB didn't listen to it, but it's there. I was doing it because I'm following my doctor's recommendations. The tribunal will look at it. The tribunal does not dismiss and disregard the opinions of your treating practitioners unless they have some concerns about the merit or the credibility of the report that's being provided. But in most cases, they will look at it closely and they will accept the opinions of your treating practitioners. It makes sense. It's common sense, right? Whether the WSIB does or not, don't rely on that, but get it in your file, always. So, my friends, apart from these tips, there are certain cooperation responsibilities that you have. And there's a policy that addresses that. It's policy 190208. I'm going to put it up here. Just have a read through it. I know it's very complicated and it's extensive, and it may seem like a lot of that stuff doesn't even apply to you, but that's fine. Just read through it. Go online, bring up WSIB, put in the name of the policy like I just showed here, and just read through it. You don't need to understand all of it, but just so that you're familiar with some of it. That's very important because the WSIB will only cut you off, in my experience, under two circumstances. One of them is that the medical information doesn't support what you're saying in terms of your inability to work. And the other one is that you're refusing to cooperate in return to work activities. And they do have a right to reduce. They'll send you a warning and they can reduce it to 50% and then eliminate your benefits. So the return to work cooperation policy is extremely important. Again, it doesn't mean you have to agree with all of it, and it doesn't necessarily mean that you don't have the medical support to concur with your decision to not cooperate. But you got to have it. You got to have that kind of support. Otherwise, there's a disruption to your benefits. Then you got to get involved in an appeal. And even though you may very well be right at the end of the day, sometimes these things can take a considerable amount of time. So better to follow some of the tips that I've given you, and there's probably others I may have forgotten. I'm trying to keep things simple, but it's important to understand what your cooperation responsibilities are, as well as making sure that you have the medical support to explain why you're not able to engage in return to work activities, because the WSIB will only pay loss of earnings benefits if you're involved in a medically approved rehabilitation program. So in other words, they're paying for it, they're covering it, or you're involved in some sort of return to work activities. And outside of those two, you may find yourself in a little bit of shaky ground. But nonetheless, at the end of the day, we know that there's a lot of gray stuff that comes in the middle. And that's where someone like me or someone on my team or an experienced lawyer or paralegal can be very helpful. All right, friends. So anyway, I hope that this was informative for some of you or all. I try to provide information that is useful based on over 30 years of experience in dealing with these people. And I always try to help avoid the discontinuing of benefits altogether. I always try to find a way to resolve the issue before it gets to that point. Sometimes it's inevitable, but I do, even with our ongoing members and our clients of WSIB settlements, we always look for ways to try and avoid benefits being stopped. The only way we can be proactive in providing you with support and guidance is if we are aware of everything that's happened in your claim, so that from that point onward, we can help you manage the claim and give you information so you're making informed decisions and you're not subjected to some of the surprises that may happen and some of the pitfalls that inevitably happen in a lot of claims that I've had a chance to look at. Okay, my friends. So anyway, I hope that this was helpful. As you know, I have a lot more content to talk about. If you're a subscriber, thank you. I always appreciate that. If you're new to the channel, I welcome you to become a subscriber. It's free. It doesn't cost you anything. All of this information I provide here is free. And if you need help or hands-on help with your claim, whether it's to provide support and guidance or to deal with an appeal, then by all means, get in touch with my firm, WSIBsettlements.com, right here at the bottom of the screen. And if you have any questions about anything about this video or your claim, dealing with anywhere within those 40 years of major legislative changes, I can help you with those. And my email address is up here, joemachado@WSIBsettlements.com. All right, friends, I enjoyed spending this time with you, and who knows what's going to come next week in another video, but there's always another video. And until next time, take care.